And this is Bree's attorney speaking right now. Gretchen, can you do comments? And the particular things that she was asking for as to my client's travel were not in the orders, were not things that we had even discussed as part of the DVRO trial, and she was demanding that we send them to her. When I refused during our meet and confers 1 hour after those emails stopped on the 17th of September, she served discovery for the same information. So the discovery has nothing to do with 3044, but about her client wanting to know, I guess, every single little thing there is to know. They are so fucking dramatic. Every single little thing there is to know about my client's life and her unsupervised visits with W that is not in the orders, but per Ms. Butnick's own admission via email was more of her, I guess, imposition as a professional concerned about what her client, I guess, would hold her liable for. And I suggested that maybe she talk to her client about that in private, because that seemed more like an attorney-client relationship issue, but it's something that she could use to impose non-existent orders on my client. So when we got the discovery, I gave her my client's old lease that's now since expired, since she's in a new place. But I gave her that, and she's right. We objected to the other stuff. The court, hold on. I'm not dealing with the motion to compel. Ms. Fonseca, okay, I understand that, but she kind of made that the basis of her argument, so I just want to make sure that I was well heard on the discovery not being about 3044. The court, okay. So your position is, and to the extent that your position is, her argument that we needed an evidentiary hearing or more time because she needs additional information, that's in the discovery request. That would be relevant to 3044, and you're saying the information she's seeking is not relevant to your client's efforts to rebut the 3044. Ms. Fonseca, correct. This hearing has been set for 6 months, and again, using a quote that I put in there earlier from the 827 transcript, it was specifically set for this. So she's had 6 months of opportunity to file pleadings to say why Brianna has not overcome the 3044 presumption, but didn't do so. And like she said, there is no deadlines on that. We both know if it's a supplemental pleading, that's more or less a made-up pleading that we're using just to update the court on everything that's occurred since we last saw you. But we last saw you 6 months ago, and again, if it was forgotten that this was the purpose of the hearing, the court, counsel, Ms. Fonseca, we highlighted that in the New Year's Eve pleading. The court, respectfully, you've got to stop with the forgot. Remember, the court started with, I didn't feel like I needed to set ground rules again because I've done it in every hearing, but I'm going to do it again. Let's stop with the, she may have forgotten, they said this, that's snarky. Let's keep it on the facts because we don't have a lot of time. And part of the reason we don't have a lot of time, frankly, and we're always in a rush, is because our time, I think, was wasted with personal attacks towards each other and a lot of the undue consumption of this court's time. Despite multiple efforts, I told both of you that the things I was looking for, that this wasn't a defamation case. Yet we saw hours and hours of videos and texts and things that really, it sounded to me like neither part was really paying attention to what the court was saying. So I just want to clarify a few things. Yes, we were rushed. I don't think that's on the court. I think she meant on the court. I think it's because both parties didn't follow the court's directive. And I appreciate it. I didn't mean to. You had a great flow and I didn't mean to interrupt. But let's stop with the if she forgot because that's snarky. And I think you both are much better attorneys than that. So go ahead. Last word and then. Ms. Fonseca, yeah, last word is just there is just no cause for a continuance. If we're here for the 3044 and to decide if the class that my client took met the court's requirements, I made very good faith efforts multiple times to try to confer with counsel about that and kind of just had the door shut in my face. So here we are. And again, I will be willing to give these documents to the court if it's just the people that we know in here. We could just not even have to go into chambers if you wanted to discuss the pregnancy stuff, but I won't do that on record. The court, okay, well, a couple of things. I do want Ms. Butnick to respond. I agree with you 100%. I really do, as it relates to notice and anticipation in preparation of today's hearing in terms of rebutting the presumption that was based solely on the class. I think we've all been on notice of that from the beginning of the hearing. Ms. Olsen has indicated which class she was taking. And in fact, I think that was why the court made that comment that it did. That if it's something she's already taking, I will give her credit. So we were all on notice about that. I agree with you. But one of the things I heard from Ms. Butnick, we have to go through all the factors of 3044, is a reference to, and I don't know when it happened and where it happened. I don't know how relatively new it was or not, and I haven't seen any evidence. My sense is I will of allegations of domestic violence potentially between Miss Olsen and somebody else. I don't know. But she made reference to that. That's different. That's something that is potentially a new development, and frankly is something the court might take into account. Look, I'm going to be frank. One of the big issues that has been ongoing in the request before was whether or not Miss Olsen's new partner, who I understand is the father of her current child, she doesn't have a child. I'm sorry. Actually, I'm not. To anybody in here that's pro-life, a unborn fetus is not a child. They both have, on their own, 2 living, breathing children that they do not take care of. They have abandoned both of them, moved across the country, and could give 2 fucks about the living, breathing children that they have on this planet. I don't give a fuck about an unborn fetus of this fake fucking pregnancy. Sorry. Where was I? Who I understand is the father of her current child can't be around W. And the court at the time during the hearing, mostly because the court's finding regarding her partner's involvement in, I think the circumstances of how much the court ultimately granted the domestic violence restraining order is participation in that, and whether it was her endorsement, her encouragement, and her knowledge of that. And also, I guess there was that one video regarding the diss track and a reference to that, and W being in the video with her partner was talking about making a diss track of Mr. Gacy. That's why the court at that time made that temporary order. Now, obviously, I understand that this is going to be a renewed request. I think it's in her pleadings for the court to alleviate that, especially since W is going to need to be with, should be with his half-sibling and should the father of that half-sibling be present. So, obviously, that's something a request to the court will and would have probably today seriously considered. The court's concern, obviously, is if there are allegations of domestic violence between those 2 individuals, that's something that the court should consider in terms of the 3044. Not only in terms of the 3044 process, but also in terms of ruling on Miss Olsen's request that I lift the prohibition and the ban against her new partner from being around W during the visitation. So, they are all you can open the chat. Oh, wait, no, you can't. Yes, you can. So they are all kind of interrelated. So I agree with you 100% as it relates to the case. And I think that could have been anticipated. And if that were the only issue, I would agree with you, Ms. Fonseca, that there is no reason we shouldn't go forward today. I'll be frank. The other issues were of more concern to this court. If they are true, I don't know. Hi, Brandy. I have an issue with the judge as well. I have an issue with how much leeway she gives Brianna. And I don't know if it's because I come from a different state and our courts handle custody hearings very differently and parenting very differently. I don't know. In Texas, and I'm not going to say in every case because I actually myself come from a case where things were not really handled that great. As many people know, my father, the day that my father died, he had never once paid my mother a dime in child support. He owed my mom over $125,000 in back child support. I never once saw, my mom and I and my sisters and nobody ever saw a penny of child support from my dad. So it's not every case, but in general, in the state of Texas, the leeway that Brianna is given is absurd to me. Absurd. She is allowed to violate orders left and right. Santos is allowed to fucking bark with his big ass teeth in the back. It is absurd. And this stands on both sides. If John violates orders, then violate him. The problem is that he's not violating orders. And that's why y'all can't ever find anything on him, is because he's not violating anything. He's doing what he's supposed to do as a fucking dad. I'm sweating. I have hot flashes. So much grace and she never has any repercussions. It's right. But then the second that John makes a snarky comment, it's we all have to stop and fucking hold his ass to the fire. And I'm just over that. Jesus Christ, people. Hot. Okay. Chat down. Sorry, I have focus issues. Miss Fonseca, and I guess that's my struggle. I agree with you. If those are true, then that's a concern. But counsel just brought all of that to the surface in this moment, even though there was 6 months to file. So unless she said this happened yesterday or happened, I don't know, I mean, at any time outside of the business day that wasn't yesterday, it should have been brought before the court, not via counsel's testimony, but via these officers they claim that can testify, via any pleading they could have served the last 6 months. So I think it's rather unjust to my client, who has been, from our perspective, doing what she's supposed to do, doing what she's supposed to have been doing pursuant to the court's orders the last 6 months, and came in with the materials to share with the court and opposing counsel. Materials which could have been attached as exhibits, but we don't want to expose her lease, her new address, to social media. First of all, numbnuts, my client's doing everything she's supposed to do. They have actual hard proof that your client took the child out of Dallas County and surrounding areas 4 hours away, dropped him at Santos's family's house, and when the police showed up, the baby was there with Santos's family and you were not present. So many things were broken. You quite literally are not meeting the standards of the court. What? But somehow, John and his attorney are wrong in this situation. Because she didn't file it soon enough for your liking, so that you could be prepped to come with some bullshit response, Lindsay. I'm hot. So hot. Sorry, I'm trying to get my fan going. I'm sweating in places I shouldn't be. Let me keep going. These things in these specific documents also protect, for example, a third-party Airbnb host. Random strangers that claimed they were reaching out on behalf of John messaged the host of her rental back in the November visit, trying to get videos from the visit, talking a bunch of smack about Brianna to the owners. So that person's name in the Airbnb messages between her and my client is part of this packet, which we didn't want in the public file for obvious reasons. So we came in fully prepared to move this forward in the way that we thought the court was very clear about. You know, the purpose of today being, instead, it feels like we're kind of being sandbagged, bitch, with new information, which again, unless it happened last night, this information should have been put before the court before right now. Miss Butnick, if I can respond, the court. Okay, go ahead, Miss Butnick. Miss Fonseca, to all of that. The court, yes, Ms. Butnick. So first, with regards to the first concern about Miss Olsen violating the order in the sense of Santos being present for visits, we did file an ex parte to try to address the issue. You filed a response. That was October 21st. I understand from the court's position, it wasn't a life or death immediate emergency, but the issue were set forth in that motion, as was the issue of domestic violence between Santos and Miss Olsen. I will let the court know that this is one instance that we are aware of. There are more. We also apprised the court and responded as to the issue of Miss Olsen telling Mr. Gacy W wasn't staying at one location, and then evidence coming out that she had appeared to be at an undisclosed hotel, refusing to tell Mr. Gacy, the custodial parent, where the child was. We then, as of Christmas, so a week ago, 10 days ago, we found out that W was in San Antonio, not Dallas. That's not a surrounding county of Dallas, in the care of Santos's family members without Miss Olsen present. I just got a report from law enforcement. I have not had time to issue subpoenas. I was waiting on the report to make sure that it was worth subpoenaing out-of-state officers to testify at a hearing. Like, she's doing her job, Lindsay. Hello? The discovery. To touch on that point of the discovery, one of the demands is a demand for law enforcement records by Miss Olsen. We've also asked for verification of where she has been. That speaks to the 3044 issue of if the DV-130 and the attached custody orders are being complied with or not. We have reason to believe that she is telling Mr. Gacy she's in one location with W and actually spending time at another location. This is relevant because part of the issue that led to the restraining order filing was Miss Olsen at that point had twice removed W from the state when she was supposed to exercise visits. So there is a very serious concern that if she's able to now travel to Los Angeles or further restrictions are lifted, that Mr. Gacy, the custodial parent, will have no idea where his child was. And that is particularly concerning when we have reason to believe, and I've seen videos of Miss Olsen in what appears to be mutually abusive relationship. On top of that, I agree with the court that the issue of 3044 and rebutting that presumption is not as straightforward as, here, I did a class. Anybody can sit through a course and complete it and completed a course and get credit for course completion. The issue that I expressed to Ms. Fonseca months ago was the day that Ms. Olsen completed the course was June 20th, 2025. There was testimony by Ms. Olsen during the restraining order hearing that on June 21st, 2025, she was laughing about sending Santos or going with Santos to a hotel to try to threaten John. So my position is, I don't think, even if the course itself is satisfactory, I think there is an issue of, did the course resonate? Did she take anything away from the course? And 3044 is a serious statute, right? It's important. It protects children from perpetrators of abuse. And I think there is a very real concern that Miss Olsen still has not learned anything. And even the pleadings that I skimmed, I fucking live for Miss Taylor. And even the pleadings that I skimmed, and part of my issue and request for setting this for an evidentiary hearing date in the future is that it is Miss Olsen's burden to rebut the 3044 presumption up until December 31st. Alexa, pause. Alexa, pause. I'm sorry, I didn't know music was playing. She has filed nothing to try to rebut that presumption. And so, for my purposes, coming into today, there wasn't much evidence to put on. There was no effort to rebut the presumption. I understand counsel and I had discussed a class, but again, a class alone, completion is not sufficient to rebut this presumption. Pause. Open the chat. And I want people to focus on opinions of what I'm about to ask. This is what I mean by submit it to the court. The court will make an evaluation and see if you have met the standards of the court. Because John's attorney does not get to make those decisions. Right? John's attorney doesn't get to decide whether or not the course that you took damn near fucking 9 months prior, or however long, 9 months prior, will suffice. The court makes that decision. So what are you not understanding? Submit it to the court. Stop asking John's attorney for her opinion on whether or not this is good enough or not. It doesn't even matter what she says. If she says yes, they still have to submit it to the court. She also forgot to mention about texting GA. This is from this January, though. It's hot. I just don't understand. I don't understand all this back and forth. And the problem it's not really a problem. The issue that I have is that I feel like the judge oftentimes, whenever she speaks, because she's frustrated with Lindsay, Brianna's attorney, she then tries to almost blanket statement it across the board for both attorneys as if John's attorney is doing what she's doing. And that's just simply not true. You haven't even read the part that's really going to piss you off. Well, where is that? I may not get to it. She definitely does, Danielle. What she's supposed to do. I think I missed the job, or I missed the point. Can you submit more evidence other than what he already submitted? I don't know. I don't know California courts. I don't know when deadlines were. Then she would have not. She would have not. It would not have properly rebutted the 3044 presumption. She would not have met the standards of the court, the orders of the court. She would have supposedly would have been penalized for it. However, they don't seem to ever penalize Brianna. They seem to just let her do whatever the fuck she wants. I don't know. This is my first time reading them. I'm only on page 26 of 109 of this transcript. Okay. Yeah. Everything 2K does is a problem. I literally can't. I'm sweating. It's that Adderall working overtime. Who the F puts he said on live? I smell like calamari. Not calamari. What does that smell like? What's calamari again? Snails? All right, comments off. Let's keep going. I think it's a very, very real concern that requires testimony and evidence of accountability by Ms. Olsen, and I think restraining orders are serious. I think abusive relationships are serious. I think violations of court orders are serious. And to have this very flippant attitude about, well, I did the course, and just so your honor is aware, I've seen video of Miss Olsen live streaming while she is doing the course and asking her followers for the answers and making a mockery of it. And so we will show the court that video. And so it's more than just completion of the course. And I think there's so much more. There's so many issues, and the accusations that were set forth in the pleadings that were filed at the very last minute, and there's reasons I haven't asked to strike those. I would love to cross-examine the respondent on the statement she made in the declaration she filed on the 31st. 31st. Ew. As to the statements about remaining in Dallas or the surrounding counties with W. She made a comment about how she was not able to travel to Texas because she's afraid if she doesn't have health care in Texas. She left the very next day because she's afraid if she doesn't have healthcare in Texas. She left the very next day to go to Paris and was in Paris. So there's just so much. And then discovery, again, I asked for law enforcement records. I asked for, anything related to any impediments of travel. Confirmation of lodging, details about who was present with you. We believe Santos has been present for all of the visits. Knowing who has traveled with her, who has been in the Airbnb is relevant. It gives us information on who we can depose, who we can gather more information from, but she is denying it. And I think that she will see that at the evidentiary hearing, she will come up with some kind of excuse to try to justify or minimize what's been happening. But that's been happening. But what's been happening is for a year now. She has completely disregarded every single order the court has made. Let me tell you something. The difference in just ability to deliver arguments, Taylor Butnick wipes the fucking floor with Lindsay Fonseca Esquire. The court. Okay, I'm going to let you respond. I'm definitely going to let you respond. You said something and then you went off and said some other thing. So I want to revisit that. Part of the reason, Ms. Butnick, understood. The court indicated we had talked about this, and I'm trying not to get too much into your privacy about when the child is due and when there's travel. Ms. Fonseca, I have that for you. The court, okay, that's fine. When is the baby due? Ms. Butnick, I will say on the record this summer, I will give you... We're on baby number 6 in the last 10 months. And I'm not making fun of anybody who has miscarriages. I don't believe she's having miscarriages because I don't believe she's ever been fucking pregnant. She's the one who makes fun of people having miscarriages. She fucking makes it a mockery and makes getting an abortion a mockery. And I'm all for getting an abortion. I will say on the record this summer, I will give you the documents. The court, December. Okay, that's fine. December? Wait, what? Hold on. Let me just read this again. The court indicated we had talked about this, and I'm trying not to get too much into your privacy about... Hold on. Okay. Sorry, my husband's trying to take care of something for me so that I can do this. I should be grateful. Be grateful, be grateful, be grateful. Okay. Let me back up. Stop typing in the Discord, please. Stop typing in the Discord. I don't know how many times for the last 17 months I have asked y'all to stop typing in Discord when I'm in there, when I'm on live. The court indicated we had talked. I just muted it, so y'all can go ahead and talk if y'all want to. The court indicated we had talked about this, and I'm trying not to get too much into your privacy about when the child is due and when there's travel. Miss Fonseca, I have that for you. The court, okay, that's fine. When is the baby due? Miss Butnick, I will say on the record this summer. I will give you the documents. The court, December, okay, that's fine. Hello? But there are some concerns about her traveling and her ability to travel at some point, and that's why we set the hearing for now, because there was concerns about her ability to travel. Miss Fonseca, I'm sorry. Miss Butnick just said something about after there were representations about her ability to travel and things like that, then she went to Paris. Is that correct? Did she? Miss Butnick, yeah, she did. Miss Fonseca, just so the court is aware, in December of 2025, she was in Paris. The court, in December of 2025. Okay, Ms. Butnick, December, late November, or early December. The court, look, I'm not a doctor. I'm not an OBGYN. I'm not sure any court order specifically prohibited that. I don't think it did. Obviously, if it didn't, I would want to sort of make considerations in terms of changing the custody and visitation about her increasing potential inability to travel to Texas. But that's kind of a side note. I'll just put that aside for a second, okay? I want to hear from you, Miss Fonseca. But again, I'm not sure I want to. There's so many issues here, and I'm to refocus everything and just direct the parties to what the court thinks is relevant. I do agree with Miss Butnick from the perspective of, well, I know 3044 says whether or not somebody completed a class. I mean, I don't know if you've heard this before. I've said this in other cases. Just because somebody has a certificate from a class doesn't necessarily mean they took away from what they should. They took away from what they should from a class. That's assuming they took the class. Because my understanding is that, I don't know if it was an order or a suggestion that Mr. Gacy take a parenting class. And frankly, I think both these parties should take more parenting classes. I do. I think from what I said since they came here, I think they continue to make some decisions, which I don't know if it's a product of age or a product of this being their first child. But I think there is still room for improvement from a parenting perspective. Balancing that against, look, the reality is they make their living and they make a good living from their social media presence, which involves their child. Kind of. I don't know how else to say it, because I know that there's going to be some naysayers. Hold on, let's get back to it in a second. Let me finish this part. Which involves their child, which, as I've indicated, the court is not happy about. But I recognize I don't think at this point I can prohibit, and I also understand it's the source of their living, so I get that. But let me just say really quickly, the bulk of what John does on the internet is does not involve W. I understand that John sometimes includes W in his Snapchat stories or whatever. Sometimes. The majority of the content that John puts out and the live stream, I don't hardly ever, I can't tell you when I've seen him in a live stream, the last time I've seen him in a live stream. I'm tired of things that get placed on Brianna, or that Brianna's doing, things that Brianna's doing getting placed on John. Does that make sense? Brianna makes W, well, really just any child that she can possibly get her hands on, whether it's Root Beer's fucking twins or her fake 75 babies. She's been pregnant 93 times this year. She's gone to 74 fucking, what are they called? Scan, what are they called? Ultrasounds. None of which are real. I'm just tired of that. Okay. But let me go back to the issue regarding the class and whether it was done in a meaningful way. That's one issue. The second issue, I'll be frank, it really is, and I haven't gotten an offer of proof of that, but if there are concerns about domestic violence between her and her new partner, that is probably number one on the court's list. That is number one. Everybody please tap the screen, and if you can hit share and repost, that would be lovely. And if you haven't dropped your daily heart me, please drop your daily heart me. Thank you so much. God bless you. Oh my God, Josh. I don't know. If I could get through this section. He's running to the store for me, which I knew was a huge mistake, but if you know my husband, then you would understand this. Hurry up, respond. Okay. The second issue, I'll be frank, it really is, and I haven't gotten an offer of proof of that. But if there are concerns about domestic violence between her and her new partner, that is probably number one on the court's list. That is number one. So if there is, and I haven't heard any kind of offer of proof, and I know we have an evidentiary, but that is absolutely something the court would want to know about and would want to assess before I made a decision. That's issue one. That has a much higher priority than whether or not she completed the class in a meaningful way, though that is still important. Issues about, what was she in Texas, was she not in Texas, or where she was, that in and of itself is not as relevant other than if there is, indication that the visitations were not by her, but were by somebody else's family. I mean, again, how is that not important? I'm sorry? She took the child out of Dallas County. She was 4 hours away. She dropped W off with people he does not know, has never met, has never been around, and left him there. The police showed up and can verify this. How is that not fucking important? I'm sorry? Whatever. That in and of itself is not as relevant other than if there is, indication that the visitations were not by her, but were by somebody else's family. I mean, again, I understand that at some point her new partner will be involved in her life, but, and the court recognizes that's the reality of it. If there is indication, let me pause there for a second too. Yes. At some point down the road, when she has proven to the court that she is capable and responsible enough to have said individual, fucking Sandra, around said child, and when he is no longer a danger and threat to said child. What am I missing? I'm not saying it is or it isn't that there are some wholesale disobedience of the court's orders that relates to that previously. It just raises some concerns to this court, not to punish her, but of course not to punish her, because why would we punish her? Hey. B. What, Lola? What's wrong? Go lay down. Go lay down. B. You stop. Let me open this. Sorry. I mean, look, everybody knows why we're here. We're here because he used the kidnapping word and the court never made a finding of kidnapping, but we had to have law enforcement come to where she was staying after a court order and order her to return the child. So there is a history of not obeying the court orders, very seriously not obeying the court orders, and the court continues to try to weigh everything in this case. Of course you didn't rule that there was a kidnapping. Because... whatever. Even if there wasn't a kidnapping, there was definitely a holding hostage. Like, I'm sorry. When the fucking police show up to pick up the child with a court order in hand and you refuse to do so, you're holding that child hostage. Anyway. Very seriously not obeying the court orders, and the court continues to try to weigh everything in this case. The fact that she has a new child and the partner of that child, she doesn't have a new child. and try to the fact that she has a new child and the partner of that child and try to accommodate her pregnancy and the travel and all that, and the court was sort of working through all of that, and then I hear references, which is undisputed, that I'm trying to accommodate and let her travel. The court made all these orders, and I'll be frank, I was considering, in light of potential restrictions in her travel, making some visits in California, but then I hear that she was in Paris in December, so it's hard. I kind of need to see the whole picture and to put it into perspective to say, yes, she's overcome the burden when there are these other things that, frankly, at least are being presented as a serious concern. I've made no findings, and I don't know if you have an offer of proof regarding allegations of domestic violence between her and her new partner or anyone else. Ms. Butnick. Ms. Butnick. This is Ms. Butnick. This John's attorney. So if the court pulls up our ex parte that we filed in October, there's an Exhibit G. This is just one example, and that's because it was the most recent. This was an incident that occurred on October 11th, 2025. I have attached stills of the video, but I do have the video that I can play for the court at a hearing. You can see Miss Olsen pushing him and shoving him, and I will let you know, the video goes on, and there's quite a bit of that. The court, and that was filmed. Well, that's a silly question. That's what the judge said, not me. Miss Butnick, Exhibit G. Yeah, I took screen captures of a video so the court would get to watch the video. The court. And was W present? Ms. Butnick, W was not present. But I think the issue is we have had enough of these exchanges or interactions that have either been filmed or we have become aware of where there is a very significant concern that this is happening so frequently, the minor child might be present if he is allowed to be present for visits, or if she is allowed, more liberalized time. We're also aware of an issue where law enforcement was involved in June of 2025, where in that particular instance, it was Santos who was arrested. There's more evidence, but I don't know that I want to tell the court all of our evidence at this juncture. The court, okay, look, I'm not doing the evidence you're hearing now, but I wanted just a general offer of proof. If there's something there of this is, go ahead, Ms. Fonseca. Ms. Fonseca, look, I told counsel in the meet and confer, this is Bree's attorney, process on her discovery before she filed her motion a few weeks ago. I paid my dollar to do the name searches on both Brianna and Santos for LA County for criminal records or any other civil case related to domestic violence. Both of their names have no hits, so I told her, I don't know what you are asking us to produce, not just my client, but on a third party, specifically Santos, because it seems like that's what she's asking for. When you can search LA County's records yourself using a name search and or date of birth and see that there's no cases there, there's no records. So that's a lie. Maybe not in LA County. Where is Catalina? I forget. I'm the one who found the records. I'm the one who called and got the records. I did it on live. So I don't know what she's asking to be turned over. The court, again, we're not doing the motion to compel today. Ms. Fonseca, right. As to the class and the mention of, I guess she's alleging that there was a violation of the temporary restraining order on the 20th of June. If the court recalls that specific incident, according to John, and I think the court kind of just drew the connection that we were saying the court drew back at the time of trial. One of the main issues the court took with Santos' involvement as to this piece of John's testimony was that Santos allegedly was outside of a hotel where John was staying and John was inside and he was scared. It was Brianna's fault and Brianna was orchestrating it. Well, what we filed with the court last night, but it got rejected, so it's in the system as of this morning. John was actually live streaming from the airport with one of the two buddies. Both of them are named Chris, with one of the Chris's that was present at our restraining order trial. They were both physically present. They're both good friends of his. He does business with them. Specifically, this one that he was with is living with John and his mom and W. No, he's not. Shut the fuck up. So him and one of the Chris's were at the airport. They were live streaming. The other Chris calls from somewhere near the hotel saying, I'm trying to get Santos here. He's laughing about it. John is saying, hey, be careful with what you say. We're on live, laughing about it at the airport. So John's testimony given across 2 days of trial Because if the court remembers, the first day we went through most of his allegations, he had no dates at all. The court, wait, hold on. I don't mean to interrupt. I want to refocus us. I'm not really sure your point in all this. I'm not saying it's not serious. I'm saying what is it? So what is the conclusion I'm supposed to reach? That the 3044 presumption shouldn't even apply because the restraining order was issued in error? If so, then I think you would have to make a request to set aside. Ms. Fonseca, no, not a set aside request, not an appeal. This is, and I quoted the court as to what you said on the 27th, if I find evidence of John doing the same things online that he's sitting here complaining about, that will go to his credibility and to his legitimate feelings of fear over these allegations, specifically related to Santos. So we were just bringing to the court's attention that John took the stand across 2 days of trial as to that specific hotel incident. That incident, at least we felt like, seemed to be one of the, I guess we'll call it, golden ticket pieces of evidence that you really considered to be part of the basis of your granting of the restraining order. The court, absolutely. So my question to you again, and I'm not trying to be rude, but I'm trying to do this in an organized fashion. To what end are you, because you just said, I'm not asking you to reconsider the restraining order. Ms. Fonseca, no, correct. The court. And to what point, as just a general discrediting of Mr. Gacy if he testifies going forward? Ms. Fonseca, yes, bringing it to your attention because of what you said of wasted about credibility on that particular topic. I don't know what you meant to say there. So to show you the live stream that he was actually part of and what was said and the physical violence threats that his two friends, again, one of those friends currently living with him, no, he's not, and W, the threats of physical violence, where do they get their information from? That were specifically made during that same incident against Santos by his friends while he was sitting right next to one of them, the court. So again, through your point is, I'm trying to put that to what you're asking of this court. You're asking this court, I think in your papers, to lift the prohibition against Santos. I'm going to use his first name, no disrespect. Ms. Fonseca, that's his first name. The court. Okay, Santos to being around your client NW because to the extent Mr. Gacy testified that he was in fear of Santos, that claimed fear is lacking in credibility because of this evidence you brought forward. Is that, Ms. Fonseca? That's one side of it. The other side is because of what Ms. Butnick said about the class, that there was this alleged violation that day that she completed the class because she completed the class June 20th. So that was to bring light to that comment that Ms. Butnick made and to the comment that made that she'd seen videos of my client basically goofing off during the class. Those videos she's referencing are about the Our Children First, the premeditation class that she took before I was even attorney several months prior. No, it's not. Listen, Lindsay, you've got to get your shit together. As I told Ms. Butnick, and as she could have contacted the facilities, you know, the owner that conducted the class and confirmed these were private classes taught by the facility's owner, who is a licensed therapist to my client and my client alone via Zoom. There were 12 lessons at 1 hour each, and then she got a completion certificate with a rating of excellent. I'm screaming. With a rating of excellent being the highest of 3 ratings at the end of her class. I'm trying to find a stopping point so I can open the chat up. So we understand that 3044 is not just about the class. I was simply just addressing the comments that counsel made. Another comment that really stuck out to me as her saying that my client was moving W around during her visitations, and she kept saying custodial parent, but my client, the custodial parent, doesn't know where the child was. That was the basis of our dispute in September after we left your courtroom that led to her serving this discovery. So, as she said, my client doesn't know the minute-by-minute location of where W is, correct? Because there are unsupervised visits. These are unsupervised visits. You don't get to micromanage my client's location on a minute-by-minute basis. She was required to provide the address of where she is staying in advance of the visits on our family wizard, which she's done for John every single month, well in advance of the visit starting. Pause. Open the chat. Let me read this again. She was required to provide the address of where she is staying in advance of the visits on our family wizard, which she's done for John every single month, well in advance of the visits starting. She's required to provide the address of where she is staying. John's attorney is arguing that she is submitting an address of where she is staying and then changing the location of where she is staying. Am I fucking nuts? Have I lost my mind? That's literally her argument. Is that you are lying about where you're fucking staying, moron. Daddy, chill. Sorry, I'm fucking sweating too. Oh, what's this? Oh, puzzle piece. I'm fucking sweating. Hi, Pookie. The reason the comments go off is so that I can focus, because I'm so bad at, if I see a comment pop on the screen, I want to know what it says. The judge is concerning. I absolutely agree. The judge has been concerning for me from jump, really. I mean, like from the time that she took over, has been so concerning. Like, all of this is concerning. Thank you, Amy. Thank you, Sup. I was going to say love. I don't know why I said slut. I'm so sorry. Hello? Why would you say that? I don't know why I said slut. Ah! I'm so sorry, Mama. Take your fucking bubblegum back. I'm so sorry, Amy. I don't know where that came from. No, I'm not. How do I turn those off? Yes, it's the 304s and the 3044s and the... I'm Amy. I apologize so much. I didn't mean to call you that. I agree, Jazz. Thanks, Amy, you slut. I don't even know what made me say that. God, I can't breathe. This is it's so hot. Let me send this to him real quick. Jesus Christ. Okay. Slip of the tongue. Yeah, it was slip of the tongue. Thank you for your heart puffs. Can everybody drop their daily heart me if they haven't already? That's all I ask. All right, let's get back to reading. Comments off. If she wants to take W to the park or to the mall or to a friend's house, she does not have to. That's not what she's asking for. What is not clicking? What isn't registering? She does not have to tell John each time her and W are getting in the car to go someplace, just like he doesn't have to tell her the same thing. She doesn't even ask. She doesn't care. She doesn't want to know where her child is. As long as she doesn't have to take care of her child, she quite literally doesn't care. She doesn't care who's taking care of her child. It could be John. It could be John's mom. It could be one of his moderators. It could be Chris Different. It could be fucking Mop. It could be Mop's dog. She doesn't give a shit. As long as she doesn't have to... Hi, Kimberly. Hi, honey. I miss you so much. As long as it's not her, she literally doesn't care. At all. So, I took big issue with that part of Ms. Butnick's last rebuttal because that is the main basis of the discovery. Who you're traveling with, who is staying with you, etc. Yes, because there are direct court orders that a certain person is not supposed to be at visitation. She didn't ask if she was going to take W for a fucking stroll down the sidewalk. She's asking who's going to be staying in the house at the visitation. because there is a direct court order, which you end up violating several times, one of which is caught by police body cam footage. You fucking moron. What are we talking about? I'm hot. Excuse me, I'm so sorry. As I told Ms. Butnick and explained to my client, and we admitted we don't have anything to hide, she took W out of Dallas and took him to San Antonio, directly violating court orders, left him with people he doesn't know, and disappeared. And the cops had to be called. You stupid cunt! Sorry, I had to let that out, okay? TikTok, I apologize. I love you. Everybody hit share and repost. I'm so sorry. I had to let it out. I just had to let one out. I'm so sorry, TikTok. I love you. TikTok shop. Buy everything you ever will own in your entire life. And from the TikTok shop, buy your next house and your car and your next child from the TikTok shop. I was about to do the prayer. I'm not even Catholic. Or whatever that is. I don't even know. Anyway, sorry. Hello? I need help. My Adderall kicked in, bitch. She's on one right now. Okay. Let me focus so we can get through at least half of these. There is no order saying that Santos can't... Oh, wait, hold on. And we admitted we don't have anything to hide. Santos is traveling with her when she goes to Texas. There is no order saying that Santos can't do that. Fair. Santos is from Texas. He has family and friends there. He has businesses there. Lindsay, stop. What businesses? He has a failed food truck that... Where's that at? Also, What? What business? What? He's a fucking 20-year-old drug addict. Like, let's be so for real about the situation. And I'm not hating on drug addicts. 13 and a half years. Let's go 13 and 3/4. Okay, relapse in December, back in a recovery program. I am fully on board with drug addicts getting help. They need help. Neither of them want help, and this is why they're making the decisions that they make. On top of the laundry list of psychological issues that both of them have. And the fact that they're just shitty fucking people. And don't want to be parents. But I digress. There is nothing wrong with him traveling with her. There's nothing wrong with him staying at the same place as long as it's not during her visitation time with W. That is apparently a different understanding between me and Miss Butnick because according to what she said via email and just now in her last rebuttal, she believes that John is entitled to minute-by-minute location information. Keep moving. Activity information. Who is there? What are you doing about my client's visits? And that's just simply not the case. The court. Okay, for the third time, respectfully, this is why our hearing goes on. We're not on the motion to compel. This is all about... Hi, Lola Bear. This is all about the motion to compel. Wait, this is all about the motion to compel, and I want to go back to what the court said originally. And these are the issues that I think are important to explore more regarding the 3044. Number one, was the class complied with in a meaningful, thoughtful way? Really, that's subordinate to this larger issue, which I think we keep moving away from. I want to move back to whether or not there is proof by a preponderance of the evidence that there has been domestic violence between her and her new partner, because that goes to the very heart of two things. 3044, overcoming that presumption, issue one. But number two, the issue of whether or not this whole issue, which is clear that she wants to lift the prohibition of Santos being present when W is present. That's what she's more worried about than anything, is having fucking Sandra there. Or lift the prohibition on Santos being present when W is present. And look, I don't have their new child before me. Nobody does, because their new child doesn't exist. It's fake. And even if it wasn't fake, an unborn fetus is not a child. Sorry to you pro-lifers who think it is. It's not. It is an unborn fetus. It is a cluster of cells. They have 2 living, breathing children that exist on this earth that they have both abandoned and both choose to harm and neglect on a daily basis. They are harmful predators to children, point blank period. There is nothing to fucking discuss. I don't understand why we are giving them so much fucking leeway. They have time and time again proven that they want to harm children, and they will do so for fucking content on the internet. I gotta text my therapist. I gotta schedule an appointment. Give me 2 seconds. Sorry. I have trauma that I haven't healed from a child going through the same situation. I can't breathe. It's hot. Let me get back to this. But number 2, the issue of whether or not this whole issue, which is clear that she wants to lift the prohibition. Okay, I already read that. And look, I don't have their new child before me, but I do have W before me. Thank you. And you know, there were, through the course of the hearing on both parties, and I said it, and I'll say it again, I think there were some not so wise decisions by both parties in the situation in which W was put in. That is not the topic at hand. The judge herself keeps saying, I'm trying to refocus us. I'm trying to refocus us. This is why things take so long. This is why things take so long. Yet every opportunity this judge gets, she tries to link John into Brianna and Santos's bad decisions. More so Brianna's bad decisions. Because Santos really shouldn't be a part of this. He's not one of the parents. He has no relation. They're not even married. They hardly live together. They hardly even have a fucking house. Like, be so for real. What are we talking about here? They're homeless. They live in an Airbnb. We're going to open the chat in just a second. Hold on. I said it and I'll say it again. I think there were some not so wise decisions by both parties in the situation in which W was put in. But the one where the court really draws the line is if W's around and exposed to domestic violence again, that causes the court great concern, and that in and of itself alone can cause the 3044 presumption not to be overcome. So I want to really focus on that. So then why'd you have to make a dig about how both parents have put W in some not so great situations? I understand your frustration. I understand your concerns with the motion to compel. That's for another day. I certainly want to hear those. Those aren't before me today. What's before me today, I think, and I'm going to go back to, is whether or not it makes sense to continue this for an evidentiary hearing to address those issues of domestic violence. Let me just ask you, Ms. Butnick, what do you think is additional that you need more time for in terms of an evidentiary hearing, and why didn't you specifically request it? Ms. Butnick. So 2 reasons. The reason I hadn't specifically requested it yet is because, again, my understanding is it is respondent's burden to rebut the presumption. Thank you. She didn't file anything arguing that she was trying to rebut it until the 31st. The next day was a holiday. There was a day on Friday, there was a weekend, and then I got served with another declaration. So had I received those declarations from Ms. Olsen a month ago or 2 weeks ago, I could have probably put together more today to try to be ready to go. I do believe that there is evidence we've requested in the discovery that we will receive either responses in the form of documents or at a minimum substantive responses from Ms. Olsen saying documents do not exist, which would help me in my preparation because I would know what else is there and what isn't. I do have police officers that I want to subpoena about the issue of the violation of the order with respect to removing W from Dallas and the surrounding counties and where they found him. The reason I did not initially subpoena them is this happened on Christmas. Mind you, this hearing is January 6th. So let's just put it into perspective. It happened on Christmas, which is a holiday. The court's closed. Let me pull up a calendar. 2 seconds and I'll open the chat. Okay. Christmas was on a Thursday. Court's closed. Christmas is closed, or a court was closed on, no, maybe they were open. Did they open on the 26th? If they did, so be it. Weekend, we have exactly 1 week of time until the January 6th hearing is quite literally on a Tuesday the following week. Not to mention, she didn't even file her rebut until the 31st, meaning there was exactly 2 court days. 2! That the court was open. That was on a Wednesday, the 31st. The court was closed on January 1st for New Year's. The court reopened on Friday and was open on that Monday. And the court is now literally happening. What the fuck are we talking about here? What's up for debate? Like, I'm so tired of this judge giving Lindsay and fucking Brianna so much leeway on everything. Sorry. It's just insane, man. Like, listen, I don't think John is perfect. I don't think he's the perfect man. I don't think he's the perfect person. I don't think he's the perfect father. I think he is doing his very best to excel at all 3 of those, though. Why is he not given the same grace and the same room for error that Brianna is, and he doesn't even come fucking close to what she's doing or what she's done and continues to do? I just don't understand it. I don't understand it. Anyway, the reason I did not initially subpoena them on this happening on Christmas, I was out of the office and I was out of town for the holiday. When I got back to the office, we were waiting on receipt of the written police report. I just received that. I wanted to review that before incurring costs to subpoena officers to come testify at the hearing if they had nothing to offer. I reviewed the report. The report does confirm what I just represented to the court, and so I do believe these officers have relevant testimony. The other element to this, what I think would be very important for everybody, is I think Santos should testify, and I would love the opportunity to subpoena him to be here or to depose him. I asked for documentation from Ms. Olsen as to where she's living, with whom. I don't have an address for Santos. I have no idea where he is. We haven't been able to find him, but I would like to have him come and testify to some of the other things that we've seen and that we are aware of. What we've heard that I think will help us overcome a hearsay objection with respect to some of Santos' statements. The court. Okay, hold on. A couple of things. God fucking bless. Or we're just going to go back and forth. That's all we're going to do. A couple of things. Number 1, I don't want to prejudge. Maybe you get lucky. Maybe those Texas officers come testify. Maybe you get lucky. What are you talking about? What's happening here? Issue number 1. But issue number 2 regarding these incidents, because I know in your ex parte, you made a reference to Miss Olsen. And again, shame on me. I maybe should have tweaked it even better. The language to Miss Olsen not being in Dallas or sort of surrounding counties. It's one thing for her to take W somewhere else in Dallas. It's another thing if you're saying, and you said that was in October, and you said that happened again in December, or is that when you believe W was left alone with Santos' family? Miss Butnick. No. So in October, this is the thing. The judge also doesn't listen. Like both attorneys can present something and then the judge will kind of insert her own kind of she'll insert her own storyline into what they just presented. She'll be like, well, this happened. You said this. No, nobody said that. You're just making that up. She said that there was a DV situation in October and that Bree took him out of Dallas County in December. It's very simple. She also submitted this to the court. If you had read over those fucking filings, then you would know this. Okay. No. So in October, my client was provided an address to an Airbnb where W would be staying. And again, just so we're clear, we're dealing with overnights and not talking about, her taking W to the park. He was given the location where W was spending the night with the respondent. She live streams everything. So they were live streaming regularly with W at this Airbnb. All of a sudden, she starts live streaming from what is very obviously a hotel room. Oh, this is a different situation. My client asked for information about the hotel room. I had asked. We were not given information as to where the hotel was located. That was an issue in October. It happened again that we are aware of, and we confirmed in December over Christmas. So just again, maybe 10 days ago, where my client, with 2 holidays, mind you, she did it for Christmas when it was a holiday, nothing could be filed with the court, and then New Year's happened. So 2 holidays in a 10-day time frame, right? Christmas to January 6th. We've got a 10-day gap. We've got weekends in there, and we've got holiday in there, just so we're clear. It happened again that we are aware of, and we confirmed in December over Christmas, so just again, maybe 10 days ago, where my client was provided a specific location that W would be. That was in compliance with the order in Dallas and the surrounding counties. And then comes to find out, and again, this is all the challenge with everybody posting about their lives on social media, is if you're in a different location, somebody finds out about it. And so we became aware that W was actually at Santos's family home in San Antonio. And so that is why my client called, because we didn't know, right? We had no confirmation. My understanding is that respondent was continuing to pretend that she was in Dallas, which is where she said she would be. And not to mention what the court has ordered her to do, mind you. Say in Dallas or surrounding counties. And these 2 law enforcement officers actually went out to the house. Respondent was not there. They spoke with 2 individuals that were members of Santos's family. They asked if W was there. They then showed the officers W. And unfortunately, because of the way W wasn't in any danger, right? And unfortunately, the way that the restraining order is issued, the officers weren't able to retrieve W and actually bring him back to my client. And they couldn't contact Brianna because she wasn't there. So all we received was confirmation as to where he was and the fact that respondent wasn't present. I'm going to submit for that body cam footage. The court. Okay. Again, Gretchen, can you put that in notes of stuff for us to do? Again, just so we can focus the conversation, and then a last word from Ms. Fonseca, and I think you all know where I'm going with this. Again, I agree with Ms. Fonseca. Maybe I'm wrong, and I don't believe the restraining order requires Ms. Olsen to inform Mr. Gacy of the specific location prior to visitation. Am I correct? Ms. Fonseca, just the staying part. That she had to give the address of where she was staying, knowing she's having to fly to Texas. So you said, in advance of each visitation, she needs to give him the address in Our Family Wizard of where she is staying. Not the play-by-play of the visits, which his attorney is not asking for. As if we have a monitor, that is dad, attached to her hip, just the address of where she's laying her head at. The court. Okay, then I'm wrong. Then she did, and that was required. But again, I think it goes back to respectfully this repeated allegations. I'm not going to make a finding of repeating sort of what is either pushing the line, or the allegations are either pushing the line or failing. We had a huge one when we had the disregard of the previous court order of taking the child, keeping the child in Los Angeles, and requiring 3 sheriff deputies or 3 units to respond in a full. There were 6 or 7 officers standing outside, by the way, and requiring 3 sheriff deputies or 3 units to respond in a full-on standoff, basically. So now we're going to be dramatic about it, Judge, right? Now it's a standoff. And you think that that's not putting that child in harm's way. That was huge. That was huge. And that potentially could have ended much worse. I'm glad it didn't. Exactly. I'm almost done. Well, I'm almost done with this section. And in light of that, there is a concern to the extent those allegations are being made, and I'll remain open-minded. I want to hear the evidence. But if Ms. Butnick proves by a preponderance of the evidence that, the court had an order and the court was considering lifting that order today, but the court did have an order that Santos was not to be present at the visitation. And if she's able to convince the court by a preponderance of the evidence that not only was she not with W at that visit, but that W was with Santos at Santos's family's home, whether that's a danger or not, it's a violation of the court order. Thank God. Ms. Fonseca, well, I don't think that's what she said. I think she said that W was with Santos's family. I didn't hear her say that Santos was there. Lindsay, It doesn't matter. The violation is that she removed him from Dallas County and surrounding counties. I didn't hear her say that Santos was there. And that's the court. I think that the court was just talking about is Santos being prohibited from being around at the visits, which is correct. This is an order. That is an order. But Santos's family, like aunts, uncles, or parents, or whoever is not Santos, and there is not an order against that. It'd just be like if they were married living locally and W's visits were here, Santos would have to leave the family home if that order was still in place. These orders are not overly common, but I have dealt with them before, and that's the logistics of the reality of that sort of order. So again, Santos traveling with her, Santos staying with her when W is not there, W seeing Santos's family, none of that. To our understanding of the court's orders, she's totally skimming over the fact that the order says visits are the visits are to take place in Dallas County or surrounding counties. She took him 4 hours away and dropped him off at an unknown location, which she is required to give John per the orders of where they are staying. And the reason she didn't is because she knew she was violating the orders by taking him there. It's not about whether Santos was there in this instance. It's about the fact that you took him out of Dallas County. W seeing Santos's family, none of that. To our understanding of the court's orders or anything that trickles from the court's orders, none of that is prohibited. As to the DV situation, that is the court is hyper-focused on. The court, counsel, Ms. Fonseca. Oh, the court hyper-focused. I don't know if you realize sometimes your word choice is interesting. Hyper-focused. Finally clock this bitch. I'm not hyper-focused. I'm required by 3044 to evaluate. So 3044, subsection A, specifically references whether or not there's been domestic violence, not just between her and the child's other parent, but between her and somebody else. Hello? Miss Fonseca. And that's what I meant. So sorry if the word choice was not great. The word choice, you basically shaded the court by saying that you're focusing too much on this and not enough on the bullshit that I'm trying to feed you. Moron. The allegations between her and Santos. So the date that she mentioned earlier was in June, but we were in court in August for several days of trial, and Santos was even here. So if she wanted to subpoena him to testify about that, or for a later deposition, there was certainly opportunity to do that, or to present evidence at our trial about something that she's claiming happened in June. And again, because my client is my client and not Santos or any other third party, I still did my due diligence when the discovery requested that and ran the name search to see, is my client lying? Is there some sort of case that I don't know about in the criminal realm between her and Santos? Just because the DA in what county is Catalina in, dropped those, there is still an active report. I called on stream, I requested the report, I'm the one who got the report from the very beginning, and I posted it 3 fucking pages ago before y'all decided to report me and get my shit taken down. And every other clip page and T page took that same document. It's literally been spread across the entire internet. You cannot tell me that you cannot look it up. It's still, if I called there right now and requested a FOIA request, put in a FOIA request, I would still get that same document because that same document still exists. Talking about Santos, it literally verbatim lays out Santos getting arrested for domestic violence. What is there to be fucking confused about, Lindsay? What are you frazzled about? I'm going to have a heart attack. Or even if it's not between them, did either of them get, charged with domestic violence with other people? Yes, he was charged with domestic violence against Brianna. Do one of my mods have the document? I can find it somewhere on one of these 17 devices, but not right now. If one of y'all can find it, I'll love you forever. Dude, I'm livid. This shit pisses me off every time I read these. Every time I read court documents, I get like this, and I need to probably take a fucking pill. An anxiety pill or something. I don't know. A Xanax. And there's no cases against them in LA County, either her or Santos. So again, as to DV, she's testifying about all this evidence that she dates back a long time ago, and we had a full-blown trial since then, and none of this was presented during the trial, and the star witness that she's saying she would like to have, not the star witness. I'm going to read this section and we can open the chat and talk about it. And the star witness that she's saying she would like to have testify or depose, Santos, was here. And she was here. And so he could have been served with a subpoena. And I did even invite a deposition when we were conferring about the discovery. I said, if you want to ask my client specific questions that aren't about documents, because really the discovery served was about specific questions, like she admitted today, to further investigate who I might want to subpoena to come to court to testify about these things. I said, why don't you depose my client? She has nothing to hide. Ask her all the questions that you want about all the visits that have occurred since we were in trial. Depose her. The court. Counsel, we're back on the motion to compel. We're back on the motion to compel. Ms. Fonseca, I'm sorry, but it's like, if it seems like I'm focused on the motion, it's not necessarily the discovery or the motion. That's a February issue when that is calendared for. It's the evidence, because she is hinging the request for a continuance on, I don't have this evidence because I served this discovery and I didn't respond. And I'm trying to point out the truth is in the details. Bitch, you wouldn't know details if they slid down your fucking throat. Hush, Lindsay. If she's saying these allegations of DV occurred in June, but we were here the last week of August for multiple days of trial, then why are we getting another opportunity now to bring it forth? I do understand 3044 is an analysis of all potential DV between my client and John, or her and anyone else. But again, counsel's referencing something from June. She's not only referencing something from June, she's literally given you two different instances and said there are more. She just has to go through the fucking evidence, you fucking moron. But again, counsel's referencing something from June, and we were in court at a multi-day trial since June, the court. So let me respond to that. I did read the transcripts that you all provided. I appreciate that. I will note it wasn't this court reporter, but I will say they were replete with inaccurate quotes of the court that were a little troubling. And I have a laundry list of those that greatly changed the meaning, but there's a line on page 84, line 23, where the court is quoted as saying, I'm trying to undermine that. I don't even know what that means, but that's for another day, and I know you agree with it. Another line that says, that's irrelevant to everyone. Page 89, line 26. I never said that. But separate and apart, what I didn't get from that multiple times when the court tried to redirect all of you, I even said, this is not a civil restraining order against Santos. So to your point of why when it came up to the court wouldn't allow it, it wasn't relevant at the time to what was before us. So that's in response to your question. The issue regarding, I think what Ms. Budnick, you can open the chat. I think what Ms. Budnick was saying, there was some incidents in December that are potentially relevant. There was something in June, Ms. Budnick, and something in October, the court, and something in October. Oh, let me read this. So, we've gone round and round and round, but I'm still back to where I was all over again. I understand your concern about the motion to compel, and I'm sure I will hear from you. I don't mean that facetiously. I want to hear from you, and I read those discovery requests, and it would be interesting to hear from both parties regarding the motion to compel, so I get that. Sorry. Welcome in, everybody. Tap the screen and drop your daily heart means if you haven't already. Please, please keep tapping the screen. What is it telling me? Oh. What is this? I don't care about the live goal right now. Seriously, what is this? Oh my God. Okay. Confirm. Cool. Start. Great. Pin. Okay. Sure. Move. Can hit 2K and his attorney report this, Judge? They can. It's not really it was, Courtney. It was dropped because when Bree was contacted. Sorry, that's not at you. When Bree was contacted about it, she said that she would not testify against him and she would not pursue anything. She would lie and say that he didn't do it. So they dropped the charges. The state did not have enough to keep it, to uphold How far into court docs are you? I am on page 52 of 109. The judge is ridiculous. Nothing. He has not done anything to put his child in danger. Thank you for the populars. Hey. Why can't they move forward to Texas? I mean, they would have to. That's what the move away is, right? Yeah, he can. Isn't that on the table? Or no? Yeah, it's on the table, right? I don't know. I have to take a 2-second break to go potty real quick. So give me like 30 seconds. Okay. Sorry. Not you timing me. I'm screaming. She said, my stopwatch has gone off and you've been gone longer than 30 seconds. So. I'm screaming. Out of breath. I'm fat. All right, let's get back into it. You ready? Ew, not it trying to get me to fucking go live with Heartbreaky. Is she still around? Should we get back? Can everybody hit share and repost one time? Can we get the shares to 50? We're at 22. It helps with protecting the live. I know it sounds minimal, but it really does help. Thank you guys. I appreciate y'all. And if you haven't already, please drop your daily heart me. It's the only gift that I will ever ask for. Everything else is much appreciated, but not required. Okay? All right, let's get started. Sorry. I had to throw water on my face too. That felt good. What I need to do is go put my head in a bucket of water, or what did Kylene tell me? Ice water, but hello? But again, with what we have before us, again, it's a request to rebut the 3044 presumption. Also, really quickly, if you missed my live from this morning where I started the live and then I got a restriction, I'm going to download that and upload it to my YouTube channel, which is linked in my bio in the Linktree link. And this live will also be uploaded. Where am I at on time? In 27 minutes. Gretchen, can you let me know, hey, like, we need to reset or not reset. I'm going to get as much done in 27 minutes, but I need to take a break. My anxiety is through the roof. Josh has questions, I think. Oh, look, really quickly. What's up? Incident reference above, which is subject to disclosure under Government Code Section 7923.615A2 as follows. Incident time and date, 6/13/2025 at, I'm assuming that's like 1900 hours, 1922. Date of report, 6/13/25. Location, Gaviota Street, Avalon. Victim, because it takes her out, female, 25. The name of the victim is being withheld from disclosure based on, but not limited to, the following authorities. Gives you every single article and code that of why, right? Date of birth, 3/26/05. Black hair, brown eyes, 6 foot, 185 pounds. I want to see what scales they were using. Charges, Penal Code Section 243E1 PC. Battery against a spouse, fiance, person with dating relationship. Time of arrest. I don't know what the fuck. I can't read if I don't know military time. Anyway, bail amount, $20,000. The actual circumstances surrounding the crime or incident. Deputies responded to Gaviota Street, Avalon, regarding a spousal assault call. General description of injuries, property, or weapons involved. The female adult victim stated the suspect pushed her and damaged her property. This concludes there was some sort of a physical assault. He did incident reference above, which is subject. The document is right here. This is the document I found. This is me reading it on live. This is a clip page, clipping that and posting it. Like, what? There was an actual domestic violence situation between the two of them. Like, shut up, Lindsay. Okay. But again, with what we have before us, again, it's a request to rebut the 3044 presumption. We have a supplemental declaration. Frankly, I saw it at lunch when I checked the calendar yesterday. I was here late last night. The two things I saw were the deposition transcripts lodged by Ms. Butnick, and I read them. And then I see today, when I had a chance to check my calendar again on break, I see the supplemental declaration and I see the transcripts. So we're both guilty of kind of doing things at the last minute. And again, that's a problem. It shouldn't happen. It happened. I understood why, but the remedy always is to give another party more time. And especially in a situation like this. So I appreciate your acknowledgement. And I didn't mean to focus on you, but in terms of what you of course you didn't, but in terms of what you previously described as hyper-focused, again, in terms of a priority, if there's been domestic violence between her and him, regardless if there's a filing or not, I mean, you can make a finding without a criminal filing. You could make a finding from a video or testimony or something like that. So they should have the opportunity to present evidence because, frankly, that is very important to this court. Ms. Fonseca. But Mrs. Labree's attorney, but if she's saying that it occurred in October or June, wasn't the opportunity to lodge that evidence with the court all of those months between then and the present day? The court, I think she also said there's incidents in October and December, or those are about W being somewhere else. Ms. Butnick, there are so many videos online that are live streamed of the fights and altercations and references to police officers. I did file, like I said, the most recent fight. Oh, Josh must be here. Recent filing that made issue of the domestic violence specifically was the October 21st. You never text me about food. It's okay. Just aside. I'm going to take a break in like 23 minutes. Of the fights and altercations and references to police officers. I did file, like I said, the most recent filing that made issue of the domestic violence specifically was the October 21st, 2025 filing by my office where we attached clips of a video of a physical altercation that occurred on October 11th, 2025. The court. Well, that's October 11th. So it shouldn't matter. We should just We should just forget about it. You're right. Beat the hell out of each other whenever you want, as long as it's not today. You're right. The judge is fucking moron. Ms. Fonseca, the December thing, to answer your question, was them alleging that W was with Santos's family outside of Dallas County, and this is all news to me. She did not reach out to me at all about any of this information, so this is also news to me. So I can understand if she didn't lodge, if she just got the police report out of state yesterday or whatever she said, fine. But again, as to claiming that the DVRO was violated, that there's been DV between the new boyfriend and my client, and we're dating that back to October or to June, and now she's potentially being given more months to bring her evidence to the court, what's the excuse from her perspective for not providing that evidence if it happened in October or June? We could have responded. We could have had some argument on whatever evidence was presented. She might say, it's your client's burden on 3044. I don't know what this evidence is that they're talking about. I would have responded to it had they filed something, but they didn't file anything. The court. Go ahead, Ms. Butnick. Ms. Butnick. So the October 11th incident was addressed in the ex parte request for order that we filed on October 21st, 2025, served on your office, and your office responded to it. With regard to the December 25th visitation period and that violation, frankly, I didn't address it because we had a hearing, a status update hearing, and an update on what's been happening, and my intention was to update the court. The visit had already concluded by the time that I was back in my office and able to do anything. It was the day of the interaction by law enforcement was Christmas Day, I believe, or the day after, and then it was a weekend and a holiday, so there was no ability to get into the court any sooner than, frankly, today, the 6th, and it was early enough. And there was not another visit until the end of January. At that point, any urgency that you and I could have worked to resolve in real time had resolved. This is, my issue too is I was out. I was on vacation in Florida over the holiday. I wasn't readily available on my computer to go and file an ex parte. And frankly, the denial of our October ex parte, where we tried to raise the issue of W, is not where he's supposed to be. It wasn't a life or death emergency. I understand the reasons for the court's denial. In terms of an exigency situation, he was returned on time. Was he, can we show that he was physically damaged by the violation of the order? No. So I get it. I get why the appropriate time to bring it up is now or at the evidentiary hearing. And, to be completely candid, I think the violation had already occurred. I don't know what could have been done to remedy that after the fact. The court. Okay, so let's refocus. God damn, how many times do we have to refocus? Just so everybody knows, I think what Ms. Fonseca is saying, because she didn't bring forth this evidence previously, somehow, rather she waives... Hey, stop. I'm trying to talk to her. Stop. This evidence previously, somehow rather she waives her right to do it. I respectfully disagree with that. And just so you all know, I don't analyze the 3044 piecemeal. I don't take paragraph A and separately look at paragraph B. I look at the whole thing, and it's a whole picture. Did she successfully overcome the presumption? Did she meaningfully attend her class? Did she attend it in a way where she sort of learned anything from it? Not anything, everything. We're talking about... I'm going to have a breakdown. We are talking about the life of a child. Why are we talking about this as if she was asked to take some fucking civics course? And I mean this for both of them. If you're ordered to take a parenting class, why are you not taking it seriously? Why are you not giving it everything you possibly can? There's only one reason, and that is because you don't give a fuck about your kid. Period. Point blank. I'm not arguing with your mama. Well, you can't, Bree, because yours hardly ever shows up. It's fine. Did she attend it in a way where she sort of learned anything from it? Has there been additional domestic violence? And it says within 5 years. So, the code itself says you can go back 5 years. Did she comply with the court orders? It's a general thing. It's a whole sort of totality of the circumstances. I'm not taking it piecemeal. I'm not going to analyze one thing today and another thing tomorrow. I'm going to do it once. I'm going to do it once and for all. And again, we can say this and you're a very good advocate. And when we have that evidence before us, I'm going I'm going to let you argue, but I just want to let you know, I'm not sure I necessarily agree with your position that it was Santos's family. It's not Santos, because that's one of those issues violating the letter of the law versus the spirit of the law. The idea behind that is that Mr. Gacy, and I know you're trying to rebut that too, and I'm happy to hear that on that next court date too, but it was filed supplementally. It was filed this morning, so Ms. Butnick is also at a disadvantage regarding these efforts to discredit Mr. Gacy. I want to hear it all at once in one hearing. Back to my point. I mean, there was testimony that he doesn't feel comfortable with Santos around his child and the reasons for all that. So to think that, well, it's sort of a technicality and the child is not with Santos, but he's with Santos's family, but she's not there, I think that's more of a violating the spirit of the law versus a letter of the law. I'm not going to have the full argument today. I'm happy to hear more once I have the evidence, but I don't think it's as cut and dried as you think it is. So I don't want to hear all of that. And I appreciate everybody's input, but the bottom line is I don't think we're ready today. There's more I want to hear. I definitely want to hear if there's been domestic violence. I definitely want to hear if the spirit of the letter of the prohibition. I mean, because I was today, I'll be frank with everybody, I was ready to seriously consider lifting that. I understand he's the father of her child. I absolutely understand that. There's no child. There is no child. She's been pregnant for 19 fucking years. Mind you, they came out with this pregnancy this last summer, and somehow she is still not due until this summer. But, you know, if there's evidence that she continued to violate it, I mean, and then say, okay, well, you know, you did your class, and even though you violated, the time has come that she's about to have this child, I should lift it. I think that sort of encourages her to continue to not comply with the court orders. You have encouraged her not to comply with the court orders because you never punish her when she violates court orders. You don't, what do you do? If I made that finding. So I don't think I can do this in a piecemeal matter. I know that's a disadvantage to her. I'm not really sure why, without going into detail, for what purpose you want to show me her medical records and chambers, Ms. Fonseca, because none of this is public information and her and Santos intend to keep it that way. Really? I can't answer your question any further without the court. I got you. I think I'm reading between the lines here. Okay, I mean, really? And back to the court's original point. Look, if I find by a preponderance of the evidence that there was domestic violence between her and her new child's father, I think we're kind of game over in terms of overcoming the presumption right now. So that's a big one. I think we need to sort of get to the heart of that, Ms. Fonseca. And it wasn't saying, just to correct the record a little bit, that I think that they should be precluded from bringing evidence forth about DV, because like you said, the code is clear. 5 years up until now is the time frame that we're looking at. I was just saying, unless it happened yesterday, there's been ample opportunity based on the dates. It doesn't matter if there's been ample opportunity. Maybe she didn't know about it. Fuck. The code would not say in the last 5 years if it did not allow in the last 5 years. Moron. Based on the dates that counsel shared, to share that evidence so we can respond to it, or so the court can review it for purposes of the three. Babe, can you fill my water up? I have lemon in here. If you're going to use that one, you have to add ice. Yeah, actually add ice and use that one, because I think the filter in the fridge needs to be changed. Thank you. So we can respond to it, or so that the court can review it for purposes of the 3044 analysis. And I'll say it again. I feel like it was a strategic and purposeful move to not do it before today so that they could request a continuance, knowing that the continuance would likely mean that the orders remain the same. When everybody, thank you for the hand heart, Emily, that the orders would remain the same when everybody knows that we came to court today hoping that the court would at least consider the visitations be moved to California. And it seems like it was strategically set up this way to get a continuance to keep the orders the same way, which means she keeps having to travel to Texas, paying double rent, essentially. No, she's not. Anyway, all the airfare costs, doing this while she's pregnant, etc. No, we'll touch it in a second. And to the Paris thing, she did her gender reveal with W in Paris. She has now done gender reveal with the new baby in Paris. So that was where the Paris thing came from. And Santos also asked her to marry him. So now they are engaged. The court, congratulations. Who gives a fuck? They also beat the hell out of each other. You want to say congratulations for that too? Ms. Fonseca, from that trip, so yes, they did go to Paris for the gender reveal. It was a quick trip, and she's obviously now back. But it's not just the travel. It's the other things that we also shared. Thank you. Also shared in the supplemental pleading, like supporters of John's, again, whether or not he's involved, they're saying he's asking them to reach out. No, they're not. Where are you pulling that from? What evidentiary support do you have that shows that? John would never ask people, like, shut up. There are random strangers, so we can't know that for certain, but exactly, you don't know it for certain, yet you're making a claim on the record in court in front of a judge. But these people going to the lengths of finding out who it is, and then contacting the host of the Airbnb rental. They have mass reported her assistant's account on Airbnb. Not her assistant, not Graham's. I'm screaming. Shout out Graham's. Fucking idiots. The court, her what account? Ms. Fonseca, her assistant that does her bookings to keep it private as to who is making these bookings. Her assistant's account and the assistant's name and picture have now been broadcast all over TikTok with encouragement from John's supporters to mass report the assistant's account so that she is now... I've never seen this. Have y'all seen this? And maybe I'm missing it. I'm not going to say this part's not true. I've never seen anybody calling for a mass. Maybe they did. Maybe I'm wrong. We're not wrong because I don't disagree. I just don't know about it. I've never reported it, and I could give two fucks to report it. John supporters to mass report the assistant's account so that she is now precluded from making reservations on the Airbnb platform. There has been people posing as DoorDash and other delivery drivers loitering outside. You have no proof of this! Of the premises where my client is staying in Texas. So it's not just a travel situation because she's pregnant. It's not just a money situation because she is paying rent here and then having to pay for Airbnb, round trip flights, all of W's essentials that have to be bought each time she goes there. It's accumulation of all of those things. And she did sign a lease of a 4-bedroom house in the Valley, which is very child appropriate for exercising visitations here. She's paying on the lease to live there. So of course you would hope for all of those reasons that the court would at least give her a shot of doing the visitations here in California. No, you would think that the court would give her a shot at abiding by the fucking orders that they set forth in August. Yet she has been unable or unwilling to do so. Where are we at on time? Gretchen, in 4 minutes, you can open up the chat so that we can kind of debrief and talk this through. Because we're going to come to a stopping... Maybe. I don't know. We'll figure it out. But in 4 minutes, you can open up the chat. And she did sign a lease on a 4-bedroom house, blah, blah, blah. She's paying on the lease to live there. So, of course, blah, blah, blah. Maybe a middle ground would be we give them their continuance and let her at least try in January. We suggested that they split the airfare. But she could even at least... this once, do it all herself. She'll fly to Texas. John can meet her at the airport. She can pick W up. She'll fly him back at the end of the visit. She'll take him back to Texas. If that's something the court is willing to consider, we could ask for the visit to be 2 weeks instead of 1, so she actually gets some time outside of the airport and airplane. It's a couple of hours flight from Texas to California, mind you. For the visit to be 2 weeks instead of airfare to hang out with him here in California. But maybe that's a middle road suggestion that we could make to the court if the court is inclined to grant the continuance that counsel has requested. The court. Okay, let's take a break and then we'll come back at 3:05. Perfect. This is a great time for us to take a break and discuss. You can open the chat now. Oh no. I just lost brain cells listening to Lindsay. Ruthless, it'll be up on my YouTube channel. I'll post the live. I've had 2 lives today so far. What page are we on? 61 of 109. Did we actually make it to right at the middle? Also, I'm confused. I thought that she was having a what is it? At-risk pregnancy, so she couldn't travel. But now all of a sudden she's able to travel to Texas, pick up W, travel back to California, spend a week with him, and then travel back to Texas to drop him off? I thought the entire whole thing was so that she didn't have to travel. Have Bree's response to John's October. I'm sure I do somewhere. Gretchen, do we have Bree's response to John's? I don't know. If we do, just message it to me. Disclosure under government code section 7. Okay, calm down. Ew, not my voice. Okay. If not, we can get it, I'm sure, but... Oh my god, y'all. I'm about to hyperventilate. High risk, yet she stays up until 4 or 5 o'clock in the morning on live stream with Root Beer and Company doing blow and drinking. I don't know why they would do 2 weeks. If this was the other way around, they would have thrown the book at him. He would have been held in contempt. Not Shelly. Yeah, Root Beer and Go. Oh my god. That made me lightheaded, dude. She pisses me off. Every time I read court documents, I get like this. I get so worked up. Because it just... Yeah, she's eating junk food every... That part, Ariel. I just get like... So... Yeah. So here's the thing. I low-key need to take a break. In 5 minutes. We're at the halfway point. I know that that's going to piss some people off, but I cannot sit here and read another 50-something documents without taking a break. So what's a good time? I won't make it long. I'll just need I need to eat something and I need to yeah, gotta breathe and decompress because I'm so annoyed. So what about 2:30 my time? So it's 1:30 here now. Refresh bath. I'm screaming. My blood pressure is they always have my blood pressure. So an hour from right now. Is that good? Take a nap. I can't take a nap. Kendra, I'm what? Geeked. Benito, CJ, Benito and Lola, CJ says hi. We have another one now. We took over my mom's dog, kind of. Because my mom's a bad dog parent. She's a bad parent in general, but that's for another day. That's what I'm going to do. Bree's worked up from... He can't nap. What? No, we didn't. We brought another dog in the closet. I'm screaming. I mean, it's just my mom's dog that already lived in the house. It just wasn't in here, but I'm screaming, not in the closet. Does that work for everybody? He's been good, Inessa. How have you been, love? Can everybody drop their daily heart me's if they haven't already? Okay, cool. So then set notifications. Oh, yay, that's our Pomeranian's name, Benito. He's named after Bad Bunny. Yeah, set notifications and if I'm not on at 2:30, do not send me messages. I will turn my messaging off. It'll be close to 2:30. If not before or right at, it'll be a little bit after. But it'll be very, very close. I promise you. Okay? I'm going to get off in 3 or 2.5 minutes, it says. I know. Well, it's 2:30 now where you are. It's 1:30 where I'm at. I'm central. I'm in the future. I'm screaming. Shut up, CJ. Yeah, an hour. Sorry, I have to do it at set. Like, I have to do it at exact times, and I've been on for an hour and 58 minutes, so I'm gonna just wait the next 2 minutes and so some odd seconds. I'm screaming, not the dogs. Who are the dogs? My mods, because they will bother me until... Did you just add on food, Josh? Oh my god. I literally can't do this anymore. 100 degrees, Emily. Where do you live? Ew. Is it cold outside?
No.
It's hot?
Not hot. It's just like, it's actually like it's...
Never mind. I'll look at the weather. I don't know why that was a difficult question. 71. Oh, but it's sunny. It does? Like, he was just outside. I don't know why that was a difficult question. Y'all know Josh. He just be making things difficult. He starts stuttering, and then I get angry. I'm in Texas, Houston. Okay. All right, y'all. We're almost there. Love y'all. Thank you guys for being here. Thank you guys for hanging out. Thank you for all the new follows. Thank you for all the heart knees. Thank you for anybody who gifted. If you're new here, gifting is never required, but it is much appreciated. Bye, Brandy. But thank you for engaging. I know that it sucks having the comments turned off, but that's just part of it. I don't have a great, yeah. Anyway, I love y'all. See y'all in a little bit.